Let's take a look at the concept of tangible employment action as it relates to harassment and employment law. Harassment sometimes results in significant changes in the employment status of individuals. In the classic example, a manager tells an employee that he wants to receive sexual favors from her and that she must comply or her career will suffer. The employee resists this sexual advance and is demoted or fired shortly thereafter. The employee's response to harassment has had a tangible effect on her employment opportunities, and she would have a strong harassment claim. Harassment that results in tangible employment action often involves a sexual advance that can be traded for some employment outcome. The Latin term quid pro quo, what for what, or this for that, is often used to describe these cases. Some courts have also held that the prohibited quid pro quo also occurs when employees submit to unwelcome advances to obtain employment opportunities, like to get a raise, or to maintain existing opportunities, such as to keep one's job. In a tangible employment claim, the harasser must possess significant authority to influence or determine employment outcomes, or at least be reasonably perceived as having such authority. However, if a supervisor threatens an employment consequence but does not take any action when the employee refuses his or her sexual advance, there's no tangible employment action, although there might still be a hostile work environment. For a tangible employment action claim to succeed, it's critical that the plaintiff show that the tangible employment action is causally linked to the rejection of or submission to harassment. Courts do not require evidence that the harasser explicitly linked harassment and a subsequent employment decision, but the mere fact that a tangible employment action coincides in time with the occurrence of an advance is not enough. What about an employee who is subjected to severe harassment and quits to escape the situation? A resignation under these circumstances is termed a constructive discharge and is treated by the courts as a termination. If an employee is forced to quit because of harassment, that loss of employment is clearly tangible in terms of having a significant effect on employment status. Yet quitting a job is not the same as a termination in the sense of being an official act that might prompt managerial review. The Supreme Court has determined that a constructive discharge will be deemed as a tangible employment action only if an official act such as a demotion or pay cut prompts the quit. The logic of this decision is closely tied to the rationale for distinguishing between tangible employment action and other harassment cases when attributing liability to employers.